Good morning, good afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's webcast, International Update on FRAND Issues for Standard Essential Patents. I'm Naoki Yoshida, and I'll be your moderator today. It's my pleasure to welcome our presenters, Dory Hines and Ming Yang. Both Dory and Ming have extensive experience in handling FRAND problems for corporations and organizations. Dory is a partner in our DC office and is currently the leader of our electrical and computer technology practice group. She focuses her practice on patent litigation and has led teams in district courts and the ITC and argued a number of cases before the Federal Circuit, including FRAND-related issues. Ming is a partner in our Palo Alto office in the heart of the Silicon Valley, and his practice focuses on patent and trade secret litigation and client counseling in electrical arts. Both Dory and Ming are frequent travelers to Asia to assist companies with IP needs and to give lectures on various IP topics. They will share their views on the present state of SEP and FRAND issues. I hope you find this webinar informative and helpful. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. This is an interactive webinar. Just click on the red Q&A button at the lower center of the webcast interface and type a question into the Q&A window, and then click Submit. The questions will be answered today during the question and answer session, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And now I will turn it over to Dory Hines and Ming Yang to begin our presentation, International Update on FRAND Issues for Standard Essential Patents. Welcome, Dory and Ming. The floor is yours.
Thanks, Naoki, and hi, everyone, and thanks for joining us. My name is Dory Hines, and I will be starting us off. So, a few months ago, Ming and I talked, and we've been considering and looking at developments in the FRAND area, and we thought it would be interesting to do an update. And little did we know when we talked about doing that so much would happen so quickly this year. It has been quite a busy year, and especially in the last few months has been quite busy. On a couple of different fronts, we've seen a lot of cases recently squarely addressing FRAND and SEP issues, and we're going to touch on those, some agency actions. And in light of those, we wanted to talk about some strategy considerations given the changes and the developing law and considerations by agencies across the world. And then, of course, give you the opportunity to ask questions that you might have. So what we're going to cover at this webinar are the recent cases, as I mentioned, brand new case out of the UK Appeals Court in Unwired Planet, a brand new case from the United States District Court, FTC Qualcomm, a fairly recent decision out of China in Huawei Samsung, and then two more decisions out of the US, TCL, Ericsson, and Core Wireless. And in addition, we're going to look at some agency actions in Europe, China, the JPO, and in the U.S., and quite recently, in fact, just last week in the U.S. It's a lot to cover in an hour, and we're going to touch on some highlights of the decisions and the agency action as well. There is more detail to it than we can possibly cover in an hour. So if you have questions or want further analysis, we're happy to help you with that, so just let us know. So let's look at the recent cases. As I mentioned, we'll start out with the Unwired Planet case versus Huawei that came out of the UK. a recent decision there from the Court of Appeals. There had been quite a lengthy decision last year from the trial judge, which went on appeal. And before I get to the issues that were decided by the appellate court, I thought it was worth mentioning the issues that were not appealed and that were not subject to further decision by the court. And two of those were the FRAND calculation methodology and also the specific royalty rates. So oftentimes in the FRAND context, whether considering it in the context of litigation or considering it in the context of license negotiations or evaluation of a portfolio, what we're looking at are these FRAND calculation methodologies and really what the specific royalty rates are, what's reasonable, what's fair and reasonable in these circumstances. So as a refresher of what the UK court did and the issues not considered on appeal, Judge Burris, with respect to FRAND calculation methodology, expressed a preference for comparable licenses. There's a question always in the FRAND analysis whether and how much weight to give comparable licenses versus a top-down patent counting methodology, considering the total patent load, total number of patents that are essential to a particular standard, and the particular SEP owner's contribution to that total. The judge in this case expressed a preference for those comparable licenses because they, in his view, reflect real-world negotiation and real-world business considerations, then using that top-down patent counting methodology as a check. And in looking at the top-down approach, said that counting patents can be the only practical approach. And people have recognized problems with strict patent counting because it doesn't differentiate between the value of individual patents. It treats them all the same. And as we know, as IP folks, not all patents are created equal. But oftentimes in counting, that's the methodology that has to apply. And Judge Burris said, well, in certain circumstances, exceptional circumstances, you can treat patents differently, but generally you treat them all the same. Another issue not appealed, the specific royalty rates. He did say, though, they can vary by standard, and here the standards being looked at were 2G, 3G, and 4G. They can vary by applicability, whether they're applicable to the handset or to the infrastructure, and they can vary by region. Did a very extensive analysis of how to come up with those specific numbers that was not challenged on appeal. So what was challenged on appeal? Generally speaking, the issues that Huawei chose to appeal here were more generalized issues about how FRAND should be determined in this case, not the specifics, but more generally. And the issues are, was the global license a FRAND license? Was there a hard-edged or specific requirement for non-discrimination? And did Unwired Planet abuse its dominant position? And the court addressed these broader issues on appeal, and in each instance, the appeals court sided with Unwired Planet and dismissed the appeal. So generally, this Unwired Planet case, is viewed as pro SEP holder. In fact, the Court of Appeals said, just as implementers need protection, so too the SEP owners. And that seemed to flow through much of the court's analysis. So looking at the first issue is a global license, and that is a license to all of the Unwired Planet portfolio in all jurisdictions. Is that FRAND? So not just considering the UK patents, but is it a FRAND determination if a UK court is determining a license that covers patents outside of its jurisdiction? And the Court of Appeals answered that question yes. And in doing so, the court really separated a couple of issues. In looking at whether the license was FRAND, the court considered the undertaking, that is, Unwired Planet's undertaking to the standards organization. And that undertaking affected not just patents in the UK, but all of its patents. In addition, the court looked at the size and extent of the portfolio of Unwired Planet. It was there weren't patents in every jurisdiction, but there were patents in many jurisdictions, and certainly in the jurisdictions where substantial business by Huawei was conducted, in China, in the US, and in Europe, among others. Also, in the same way, looking at Huawei's business and noting it is a worldwide business. So looking at the particulars of this situation, the court concluded, and did so repeatedly, stressing the business efficiencies, that it would be impractical to negotiate region by region. Reasonable business people would not do that, and therefore determining a FRAND rate by the court must consider what reasonable business people would do, because it wouldn't be done any other way in this context with an extensive portfolio over many countries and with a business across the world. The global license was FRAND. Now, Huawei argued that imposing this global license on it was improper, and argued that the UK court should only impose a UK license, and that, for example, the court in China, where there was continuing litigation, should consider the Chinese patents. And the appeals court said no. The contract with the standards organization, ETSI, the FRAND commitment, was global. And the fact that the UK court could only issue an injunction in the UK did not mean that it couldn't assess a global license. So the Court of Appeals specifically separated those issues. The injunction that it could and did order, being limited to the UK, did not change the fact that the court said it could impose a global license on Huawei. Didn't see those as inconsistent, and noted repeatedly that it was not determining infringement or validity of those patents. It was simply determining the scope of the FRAND obligation given to the standard-setting organization. It further noted that Huawei was not compelled to take the global license, but the consequence of not taking it was the injunction in the United Kingdom. Now, the next global issue that the Court of Appeals addressed was non-discrimination. And this is interesting. There have been very few cases so far that have, in a very detailed way, addressed the non-discrimination element. I expect there are going to be more where the case law has continued to get fleshed out across the world. But this is one of the first ones that has really and very deeply addressed what non-discrimination means. And the situation here that caused that consideration was Unwired Planet had given a license earlier to Samsung on very favorable terms, and it did so at a time when it was really desperate for cash, what the court said, and it needed that money, it needed that license, so it entered into a deal with Samsung that was very favorable to Samsung. And Huawei quite rightfully argued that it should be offered the same deal as Samsung. And the court disagreed and said that Unwired Planet was not required to offer the Samsung rate to Huawei because of different circumstances. And interestingly, those circumstances were related to Unwired Planet. And its financial difficulties that it had at the time that it entered the agreement with Samsung. So the court said there was no what it called a hard-edged non-discrimination requirement, and by that it meant that Unwired Planet was not required to offer the same rate that it did offer to Samsung to Huawei. Instead, what the most important thing was to look at the value of the technology. So there was nothing in FRAND, in the non-discriminatory element of FRAND, that compelled a patent owner to offer a rate that did not reflect the value of the technology. Now, as an aside, I note this could have implications in other damages analyses. When we're looking at patent damages outside of the SEP context, we look at whether licenses are comparable. And I think the analysis here lends support for an argument that you can look outside the scope of a license for very different circumstances for a patent owner to argue that some other licenses are not comparable when they might have otherwise been considered comparable. The third issue that the court considered in Unwired Planet was whether Unwired Planet abused its dominant position. The primary issue here was the consideration of the steps that the Court of Justice of the European Union, the CJEU, had set out in 2015 in the Huawei ZTE case. And Huawei's argument was that Unwired Planet had not followed those steps set out in that decision, and as a result had abused its dominant position and violated competition law in Europe. And the court said no, that the steps set out in the ZTE case were not mandatory. Noncompliance did not mean abuse of dominant position. It said only that there was an obligation on the patent owner to notify the alleged infringer before starting the litigation. The other steps set out in Huawei ZTE were not required before litigation was initiated. The next case I want to address is from the U.S. It's a very recent case, November 6th, 2018, from the Northern District of California. And here, the Federal Trade Commission sued Qualcomm and asserted a violation of Section 5 of the Federal Trade Commission Act. The Federal Trade Commission Act is codified, and what it says is that unfair methods of competition in or affecting commerce are unlawful, and that the Federal Trade Commission can file suit, as it did against Qualcomm, to prevent and seek redress for those unfair methods of competition. And what specifically the FTC asserted was that Qualcomm refused to license its standard essential patents to competitors. And in refusing such licenses, it was breaching its FRAND commitment. And the district court here in the Northern District of California, this is Judge Koh, is the same judge who was presided in the Apple-Samsung cases in the Northern District of California. She granted summary judgment to the FTC, and what that means is she said that she didn't need any additional evidence. All she needed was briefing from the parties. There was no disputed facts. She could decide as a matter of law that Qualcomm breached Section 5 of the FTCA. And in doing that, the judge looked at the language of the standards of the TIA, the Telecommunications Industry Association, and also ADIS, the Alliance for Telecommunications Industry Solutions, and said that those policies and the language of those standards commitments don't limit the FRAND commitment to those who practice the whole standard. So in looking at this in a little bit more detail, what the Judge Koh said was looking at the substantial body of precedent, identifying what FRAND obligations are. The FRAND obligation is generally set out as an obligation to license everyone, all comers, anyone who wants a license. The judge also looked at the specific language of the policies at issue. And the TAA policy specifically said all applicants. The ADIS policy was relevant to any applicant. And again, in looking at discrimination, I mentioned the Unwired Planet case addressed discrimination. So did the FTC Qualcomm case, not in as much detail, but the district court said that there could not be discrimination against modem chip suppliers, and said that that kind of discrimination where Qualcomm was refusing to grant them licenses, that would enable Qualcomm as the SEP holder to achieve a monopoly and limit competing implementation, and that was inconsistent with the guidelines and policy of those standards. The court also noted that Qualcomm had given and received chip licenses, so that in the court's view, that Qualcomm had perhaps acted inconsistently with the position that it was taking in front of the court. And finally, Qualcomm had argued that for the standards at issue, practice of the entire standard was required, and that practice was only accomplished via cell phones and not the chips themselves. And the court disagreed there and said that the chips would practice the standard as well. The third case came out of China, and this was in April of 2018. This is Huawei versus Samsung case. And here we see some coalescing across the world of different principles of FRAND licensing and FRAND obligations. And one in particular, the court said that the FRAND obligation of the parent binds its affiliates. And here specifically, the court was talking about the defendant, Samsung, not the SEP holder, but the implementer's obligations in the FRAND regime, that Samsung affiliates in China would have those obligations as well. The court found that Huawei had met its FRAND obligations, Samsung had not, and additionally that Huawei's offer was FRAND and was consistent with the strength of its portfolio, particularly looking at that portfolio in China. The court in Huawei Samsung used a top-down analysis. So this is a little bit different from how the court saw things in Unwired Planet, where it expressed a preference for comparables with a check using top-down. Here, the court used the top-down analysis, looked at what was said to be a comparable, and rejected that. Also issued an injunction, and in doing so, and importantly here, looked at the fault of the negotiating parties, and that was an extensive part of its analysis. So how do you act in the negotiations? It does suggest, and particularly here in China, where the court is assessing the relative fault of the parties in determining whether there should be an injunction and one should issue. It's good advice to record what you do, document what you do and what you say, and keep a record so that you can assess this issue later if necessary. And with that, Ming, I will turn it over to you.
Thank you, Dory, and good morning, everyone, for those of you who are in Asia. This is Ming Yang, and next I'll be talking about two U.S. cases. Although they are district court cases, they have very important implications to license negotiations relating to standard essential patents. So the first case I'll be talking about is TCL versus Ericsson. It's a decision by the Central District Court of California last year, late in 2017. And the appeal of this case is currently pending in the Federal Circuit. The briefing is not completed yet, but there is a lot of detailed analysis in the court's decision that, number one, reflect many important views and thoughts of U.S. judges. And number two, as you can see from the issues here on the slide, the court was deciding many important issues. So imagine that you are a licensee trying to get a license to standard essential patents and trying to negotiate with the SEP owners. These are the important issues that you'll be thinking about, which is number one, what are the fair, reasonable, and non-discriminatory rates that someone should pay for a company's SEPs? And number two, if you feel like the licensor is giving you rates that is discriminating you as a licensee against the other licensees, how do you decide whether that discrimination occur or not? And number three, if the other side is offering rates that potentially are 3 to 6 times higher than what you know to be the market rate, would that alone be a breach of someone's commitment to the standard setting organizations? So let's look at the first issue, which is what are the FRAND rates? And Ericsson has a portfolio of patents that covers cellular communication standards. Most of you have cell phones or smartphones, so Ericsson's patents cover the dominant generations of standards, so 2G, second generation, 3G, third generation, and 4G, fourth generation patents. And so in deciding what is the proper, fair, reasonable, and non-discriminatory rate, the court use a top-down analysis, but the court use it only as a starting point. And as many of you know from reading many other cases, more and more courts are using top-down approach as one of the considerations because it's a very important consideration to avoid the problem of royalty stacking, meaning that because there are many patents for a particular standard, if you as a licensee have to pay all the patentees, then you don't want your total royalties to be too high. And that total royalty is reflected in the formula you're seeing on the slide as a total aggregate royalty. And in this particular case, the court has decided that proper total royalty, meaning that the maximum amount of royalty a licensee should pay for a particular telecommunication standard is, in the case of 4G, 6 to 10%. So that's the number that the court used in deciding, okay, considering royalty stacking, what's the highest amount of total royalty to be paid for this particular standard. So using that as a base, then what Ericsson is entitled to in terms of royalty rate is determined by the number of SEPs, meaning standard essential patents, Ericsson has. So that's in the formula at the bottom of the slide, that's a number in blue, meaning the number of patents that Ericsson has. And the number in green means the total number of standard essential patents that are associated with a particular standard. So in the example of 4G, the court basically in looking at the evidence identified that Ericsson has somewhere between 70 to 110 patents, and that's out of almost 1,500 patents in this particular standard. So in a way, Ericsson has about 5% of the standard in terms of the number of patents that the number of SEPs that Ericsson owns. So that's a starting point. And the reason why a top-down approach is not the answer is that the court use top-down to prevent the problem of royalty stacking, but the court also views the analysis of comparable licenses as equally important because when you are thinking about patents, like Dory suggested, every patent is different, every technology is different, every claim is different. So not all the patents should have the same or the equal amount of value. So that's why courts also want to look at comparable licenses, which is a market-driven approach. By looking at comparable licenses, the court would learn more about how much people are willing to pay in a public market or in a market where there is competition between different patent owners and there is competition between different technologies, and what is the fair value that people are willing to pay for those licenses. So in TCL versus Ericsson, the judge looked at top-down as a starting point, but modified that by also looking at comparable licenses. So using 4G, the fourth generation telecommunication standard, as an example, the court decided that in determining the 4G FRAND rates, it needed to look at both top-down and comparable licenses. And the numbers coming out from both approaches are within a reasonable range. So the court basically said the comparable licenses and the top-down analysis both act as a reasonable check on each other. So I think realizing what Dory suggested in the on-wire case, which is the determination of a FRAND rate, it's not always an exact number. It's going to be very difficult to try to come up with just one number. But I think rather than compared with other approaches in other courts, which is sometimes coming up with a range, the court in TCL decided to provide one exact number, but the court has a different number for different regions. So it has one number for U.S. and another number for the rest for Europe, and a third number for the rest of the world. So if you look at the chart here, this is the sort of this reflects the evidence that the court looked at in looking at the proper rate for a 4G license. So the two green bars, which we circle in red, those are the rates that the court decided, which is 0.45% as the U.S. rate for Ericsson's 4G portfolio, and 0.314% as the FRAND rate for Ericsson's portfolio, but for the rest of the world, meaning outside U.S. And Europe. And the blue bars, the different blue bars you're seeing, you will notice that there are sort of two big black boxes on the left. That means because of confidentiality, these are the names of the different parties, including companies like Apple, Samsung, HTC, LG, and ZTE. These are the different companies who enter into license agreements with Ericsson. But because of the confidentiality, the court redacted the information from the public record, but you can still see sort of what the different licensees have paid Ericsson. So you see the blue bars are ranging from the highest number of 0.839% to the lowest number of 0.398%. And next you look at the purple bar. The purple bars represent the court's identified rate based on the evidence and the patent count or patent numbers presented by the different parties. So using Ericsson for either 10% or 6%, you come up with a rate of 0.75 versus 0.45. But using the TCL number, which you see is a purple bar at the very bottom, that's a much lower number. So the rates that the court decided for both the U.S. and the rest of the world is somewhere sort of between the Ericsson and the TCL number, meaning it's between the two purple bars at the bottom, and also it's pretty close to the three blue bars you're seeing, which means those are the rates that other licensees have paid Ericsson. So this is the 4G outcome, and people would wonder, okay, how many patents are we talking about? For 0.45%, do you get a license of 1 patent, 10 patents, or 100 patents? So, like I said, Ericsson's 4G portfolio is found to be between about 70 to 110 patents. So here you're talking about a U.S. court decided that 0.45% is the proper FRAND royalty for a portfolio of about 100 patents. So that gives you sort of a picture. If you divide 0.45 by 100, so that's 0.0045. That's sort of the value per patent. So next, the court kind of went through the similar methodology to determine the 3G and 2G rates. But what you will find to be interesting is that although when we talk about 4G, the court look at both top-down and comparable licenses. When it comes to 3G, the court decided that the top-down approach cannot be really relied on here because the rates are so much lower than the rates you would get from comparable licenses. So if you look at this slide, the two purple bars on the left, 0.1 to 0.13%, those are based on the top-down approach. But you look at how much people are paying for this patent, and everyone is paying somewhere close to 0.4% and as high as 0.85%. So this particular huge difference made the court realize that maybe for 3G, top-down is not really accurately reflecting the value of the patent, and therefore, in deciding on the proper 3G rates, the court decided to rely more on the comparable license approach. So in this slide, you will see that based on the fact that most licensees are paying somewhere close to 0.4%, the court decided that the U.S. rate is 0.3%, and the rates for the other regions, including Europe and the rest of the world, are respectively 0.26 and 0.22%. So you can see that the TCL case is not so much about top-down or comparable license. It's about the judge's ability to use both, and in different circumstances, decided to rely on one of them more heavily than the other, as you can see from sort of how the court decided 3G and 4G rates in a very different way. And the next is 2G. And 2G, the court went back to top-down, And here, the court couldn't really look at comparable licenses because it decided that it's very difficult to unpack, reliably unpack 2G licenses. So what does unpack mean? So as many of you know, when two parties enter into licenses, there would be a lot of different ways of pricing the licenses. Although traditionally people look at a percentage number as a rate, there will be cross licenses, there will be lump sum licenses, meaning you're paying one large amount of money for many years of license. So in situations like a lump sum, which is a single payment, or royalty rate, or cross license, I think in lump sum and cross license, the court has to decide how do I look at a single large number and decide what was the exact rate that the licensee pays. So that's the process of unpacking. So in dealing with the 2G licenses, the court in TCL couldn't really unpack 2G licenses accurately, and therefore is relying more on the top-down. So this is the number that the court has decided for 2G licenses. And also, compared to 4G, here you're looking at a much smaller number of patents. Remember that for 4G, we're talking about close to 100 patents. For 2G, the court was looking at somewhere between 12 and 24 patents. So, and next, the court has to decide the important question of what is discrimination. So, discrimination means treating different licensees differently. However, just like many other courts, the Central District of California realized that it's sometimes impossible to treat every company in the world as the same because different companies sell different products, they operate in different markets, and therefore, for the purpose of deciding whether there is discrimination against TCL, the court has to decide what is the criteria for the category that the TCL is in. And the court decided that this category should cover all firms that are reasonably well established in the world market. So meaning that in deciding what are the similarly situated firms, the court focused more on the geographic scope, which is the market or where you sell your products, the licenses you require, whether you require a chip license, meaning it's at the very basic IC level, or it's all the way to the system at the system product level. And in this case, because TCL is a company who is manufacturing complete smartphones or cell phones, it's treated in the same category as other companies like Apple, Samsung, LG, HTC, who are selling completed phones. And also the court look at sales volume to decide whether firms are similarly situated or not. And therefore, as you can see, using these three primary considerations, a global and very established player would be situated differently with someone who is like a local team. For example, if a company is only selling in China, where the patent portfolio might be different from the patent portfolio in the U.S., or if a company is selling primarily in Russia and India where the patent owner might not necessarily have patents, then the court would say that those licensees are in very different situations. So here I also listed several non-factors that the court rejected, meaning that the court did not consider these factors such as whether the companies are in head-to-head competition, whether the companies have good brand recognition or doesn't have good brand recognition, and whether different companies use the same or different operating systems. To the Central District of California, these other factors don't really play into sort of the consideration of deciding whether there are whether firms are similarly situated or not. So at the end of the day, the court decided that here the red bar shows that the two offers Ericsson made to TCL, and as you can see, compared the red bars with the blue bars, and the blue bars shows what other companies and licensees are paying. The red bars are about 3 to 6 times higher, and the court said, yes, there is a breach when you offer a rate this high. There is a discrimination. So the court answered the discrimination question, yes, there is discrimination. However, the court did not find a breach, and part of the reason is the timing, because the court recognized the fact that a lot of times when the parties are in negotiation, you may be making offers that are higher than what you would agree to at the end of the day. But the fact that a licensor is offering a higher rate doesn't always mean that that's a breach of their FRAND commitment, because in this particular case, it was TCL who decided to initiate a breach of contract suit in the middle of the negotiation. So this makes the court recognize the fact that the parties are still in negotiation. They haven't decided on the final rate, and therefore it's not necessarily for a breach for Ericsson to offer or initially offer a much higher rate. So that's very important, because a lot of licensees would think that licensors have obligation to offer the exact FRAND rate, but the court's reasoning here gives you a reason to think otherwise. And the other U.S. case I'll talk about quickly is the concept of apportionment. Although earlier in the TCL case, we're dealing mostly with numbers, meaning that in the top-down, you look at the number of patents the licensor owns versus the total number of standard essential patents. But here, when you're talking about asserting just one or two or a few patents in a case, the question is, what is the burden of proof that the patent owner has to meet to show that the patent owner is entitled to a certain amount of damages? So the court made it really clear, and here the court took the unusual step of revoking the final judgment and revoking a jury verdict, because the court decided that the plaintiffs, as you can see in the last line of the slide, the plaintiff's expert analysis failed to meet the requirement. And what are the requirements? The requirement is, first, the patented feature must be apportioned from all the unpatented features. So here is a graphic showing that the big round area in blue is the entire standard. And as you know, every patent is only a very small part of the standard. So the court here requires that the patent owner has to show that what is the value of the patented feature, and that has to be apportioned compared with the entire standard. And the second requirement is that sometimes dealing with standards is easy to just jump right into the numbers. However, the court recognized that a lot of times when everyone is using 4G, that doesn't mean that the 4G, the particular technology standard, is valuable because of the technology. It could be valuable because of the fact that everyone is using them. So the court asks a plaintiff to separate the value of the patented feature from the value of the standards adoption. And as you can see, the value from the fact that the standard is a standard may be really high, but when you're dealing with a specific technology, for example, a communication protocol to save battery power, then that particular value, the plaintiff has the burden of apportion them properly. So next, we will be talking about agency actions around the world. And so let me turn the mic to Dory.
Thanks, Ming. So in the last year or so, various agencies across the world have been considering SEP and FRAND issues. I want to just hit some high points of those here. The European Commission did that and issued extensive guidance in November of 2017 addressing SEP-related issues and stressing the need to take a balanced approach in SEP and FRAND licensing. China did as well. The People's High Court in China issued SEP guidelines in April of 2018. And as I mentioned before, when the court in the Samsung-Huawei case looked at whether an injunction should issue, it adopted this fault-based approach. And that, too, is in the guidelines that the High People's Court issued in April 2018 with some helpful analysis there of considering when there's fault, whose fault it is, and what the results are, whether an injunction will issue. So I commend that to you. Also in Japan, in June of this year, the Japan Patent Office issued a guide to licensing negotiations, essentially laying out a very balanced approach and telling parties to these negotiations, and in particular parties who may be new to these types of negotiations, that there's a recognition in Japan and elsewhere, in Europe, in China, that the breadth and extent of SEPs is increasing. So there was thought to be a need to issue this guide to provide in kind of a common sense way issues that folks should be considering when entering into these negotiations, and particularly entities that have not had to consider these issues before. So what's the procedure and what are the issues to consider? And in terms of licensing terms, what are the issues to consider there? Royalty base, royalty rate, the scope, and whether to include non-essential patents, for example. One point I wanted to make sure I got to was something very recently that happened in the United States. The law in the United States in the recent past has been it's extremely difficult to get injunctions in patent cases in any event, but there's a general presumption that there are not injunctions in SEP cases. The Department of Justice antitrust chief has been speaking around the country this year and spoke at an event last week on December 7th and said that the U.S. government has been sending the wrong signal if people believe that different rules necessarily apply to standard essential patents, and particularly with respect to injunctions. He pointed out a 2013 joint statement of the Department of Justice and the U.S. Patent Office saying that in some circumstances, and what has been interpreted to be as in most circumstances or in virtually every circumstance, the issuance of an injunction or an exclusion order may be inconsistent with the public interest. And what the DOJ chief said just last week was that statement has not accurately conveyed the agency's position about when and how patent holders should be able to exclude competitors from practicing their technologies. It's widely seen as a very pro-patentee sentiment in the U.S. With some hope or expectation on the part of patent owners that there would be the availability of injunctions or exclusion orders in the United States for standard essential patents. So one question is, the antitrust chief indicated that a new statement would be coming out with respect to injunctions. The question is when that would be. There was certainly no timeline put on that, but given the activity and the interest in the antitrust chief in speaking on these issues, also given our new PTO commissioner here in the United States, I expect that will happen before too long. So I would hope or guess that it would be within the first half of next year. We wanted to also set out for you a couple of strategy considerations on behalf of licensors. The first one we take from the case, the FTC against Qualcomm. Examine your undertakings, know what you're undertaking and what are the ramifications of that. Consider, unpacking your portfolio, as Ming talked about before, by technology and generation, because we've seen different rates can apply to those different technologies and generations. Also, consider analyzing FRAND rates by region. We've seen that's an acceptable approach. That's what was accepted and found by the court in the Unwired Planet case. There were different rates by different regions, so consider that as well. Also, put some more thought into non-discrimination. Are there licenses, such as the license to Samsung in the Huawei case, that you can argue don't need to be considered or should be considered, either way, but consider those non-discrimination issues and the guidance that we've gotten on how that is. Non-discrimination in terms of the value of the technology itself, not necessarily to the standard, and also non-discrimination considering the value of the technology and not necessarily the individual circumstances of a particular license agreement. So let me flip that over to Ming to address some strategies for licensees.
So for strategies for licensees, some of them are sort of consistent with what Dory just talked about, which is, for example, number one, it's always important to go back to what are the patent owner's FRAND commitments. So to decide that, you need to look at the standard setting organizations undertaking very closely because, number one, they change over time. And number two, you want to look at the particular version that the patent owner was committed to. And for licensees, because each licensee is very different, they operate in different regions, they sell different products at different levels. So it's very important to think about how your business model and business reality differ from other licensees. So with that, you want to think globally about getting a global license, but in terms of the actual payment of royalties, you want to think about what are the countries where you sell locally and what are the countries that are most important to you. And with sort of a licensee being in a very different position compared to other licensees, you can be very creative about business options, about cross licenses, and about joint ventures, about something that is different from your something that differs your license arrangement from other licensees' arrangement. And most importantly, I think for the remainder of the points, you want to negotiate reasonably, because if the issues get litigated, it's important what the court's perception of your behaviors are, and because that may affect the ability of the licensor to get injunctions, that may affect your willfulness risk, and the fact that you have complete records and also you're committed to accept FRAND offers also give you additional evidence to work with when you're facing high risk that like injunctions or willfulness findings. So next, we'll turn to Q&A, and I'll turn the mic to Naoki.
Okay. Thank you, Dory and Ming, for covering many topics in such a limited time. Before we begin the question and answer portion of our event, please take a moment to complete our brief evaluation survey. As we strive to provide programs of value and continually improve, we would appreciate your input, which will guide us in planning future programs. Now, it's time to address questions from the audience. Thank you for asking many questions, and I think many of the questions are also answered during the webinar. But let's start with question one. The first question is in Unwired Planet versus Huawei case. What if Huawei had brought a lawsuit in a different country for the worldwide rate, and the other country court has a different approach to the FRAND rate? Dory, do you want to respond to that?
Yeah, it's a really great question. It's fascinating, and I think it's inevitable that we're going to perhaps see that happen. I think it's entirely possible that another court, having gotten to that issue more quickly, decided the case more quickly, could have determined a wholly different FRAND rate. And the appeal would be to a court in that other country. So there could just be different ways that these different courts analyze these issues, and ultimately a different FRAND rate. That's not necessarily inconsistent with the analysis of the appeals court in Unwired Planet, for example, because the court said there that there can be multiple FRAND rates. So there isn't just one, and different courts could come to different conclusions. I think it's also not too different if you look at or consider the U.S. court system, where a different jury could come to a different damages result. There isn't one necessarily right answer, but different fact finders will find things more persuasive. So I think it's entirely possible, but perhaps just given the different facts, inevitable.
Okay, thank you, Dory. We may have just enough time for one more question. So next question is, which way are the courts moving in determining the FRAND rates, device or the smallest saleable components unit? Min, do you want to respond to that question?
Yes, that's a very good question. I think the short answer is the courts are moving to both directions because of the reality of the market. I think as many of you know that the smallest sellable unit is what you usually go to for proper apportionment, because you need to decide what is the smallest unit that has a patented feature and use that as a base to determine the proper royalty rate. However, more and more courts, and including the Federal Circuit, they recognize the fact that smallest sellable unit is only one approach. You can use an overall larger system as a royalty base, and rather than using smallest sellable unit and in combination with a proper rate, you can discount the rate for the entire system, meaning that if you don't adjust the rate and adjust it low enough, it would reflect that the same result where you use the smallest sellable unit. So particularly in the telecommunication world, because the market reality is that many license deals involve royalties based on systems. So as you can see in the TCL case, the court basically used a system as a base, and therefore the answer to the question is, depending on the products at issue, the court may use a device as a base, or the court may decide to go to the smallest sellable unit.
And this is Dory. I'll just add one tiny point to that. If I could make a prediction in the United States, at least, I think we're going to see a move away from smallest saleable patent practicing unit and to more of a consideration of the device as a whole.
Great, thank you. Thank you, Dory and Ming. It's about time. So thank you, everyone, for attending today's webcast, International Update on FRAND Issues for Standard and Essential Patents. This presentation will be available on demand in the next week, so please look for an email from us with the access link. This concludes today's Finnegan webcast. Thank you for participating, everyone. Have a good day.